ruling?
Yes, Your Honor, and that matter's ready. My argument is brief. It's just a presentation. I wrote down what Your Honor said, so whatever Your Honor wants to do is fine with me.
Okay, and I'll just let the parties know I did receive the proposed order from Ms. Winkle's office, and then I did also receive and have a chance to review the objection to the proposed orders, specifically paragraphs 3 and 14. I have gone through it and compared it to my ruling at the time of the hearing. Let's start with paragraph 3. Mr. Anagnosio, do you want to be heard on any oral argument on it? Otherwise, I'll just go through my notes based on my review of your objections.
Well, yeah, it's pretty self-explanatory. I lined out the provisions, but I didn't think the court made a statement that my client's own declaration. I don't recall that at all. Even bringing that up showed lack of self-awareness. But it concludes with he is not willing to do evaluations. That's just wrong. I mean, my client has said repeatedly he'll do whatever evaluations they want to pay for. He has repeatedly said that. He's open for that. He said that in his declaration. So I'm not sure how that ended up or why it would end up as a finding by the court. We did have the conversation Your Honor mentioned about injury after the fact, and I understand you made those statements. I think my client's being convicted on a pretext and not given an opportunity, but I understand you did say that, so I didn't strike out that the statement made in this case, if someone were to happen would go back to jail, is after the fact. I think you did say that, and then I struck out the next sentence after that, that there wasn't a finding that the child would be exposed to Michelle Harrington. His evidence has been that he has not. If you recall, they tried to use some Google search things to say that he had went to Oregon, and it just fell flat on his face when it was proven that he had gone to Silver Lake, Washington, not Silverton, Oregon. And that's where the other parties live. But so I don't believe you made any of those findings that I struck out on 13 or on 3, and would ask Your Honor to strike those out. And then on 14, the dinner issue we discussed, and there's occasions where the petitioners want to feed Jaylen dinner on Sunday, so my client allows that to happen, but this says he has to feed her regardless. And I mean, if that's the court's ruling, I just don't believe we had a conversation about that. And that I believe you did say the parties are to communicate regarding text if my client's going to be late, so that there's some kind of communication about when they would be picking up. And we did set the pickup place at the Papa's Pete's in Castle Rock, so I didn't strike that out.
Okay.
But those are my objections.
Thank you. Ms. Winkles, anything you want to share?
Yes, Your Honor. The thing about the food was because Your Honor stated that you were going to keep the parenting plan how it was. That was in the older parenting plan. Your Honor absolutely did mention that the declaration showed a lack of awareness. I copied word for word. I believe it was late. The problem is if Your Honor had said it. So I would just go with whatever Your Honor states.
So I did have a chance to look back both at my ruling and the declaration. So let's just start at paragraph 3. There are some things in the proposed order that I'm going to modify a bit. So let's start at where Mr. Anagnosio started the strike and the court further takes into account. Do you all see that?
Yep.
Okay.
Yes.
So I do that was part of my ruling up through such as mental health evaluations and DV evaluations. So I'm going to leave that sentence in, and I'll tell you, when I made that ruling, I was specifically relying on pages 5 and 6 of his July 8th declaration, where he tells the court that he has done nothing to warrant the necessity of this demand, that it's offensive and belittling. That's as far as a mental health evaluation. And then the DV evaluation, he says, again, why and who's going to pay for it. Same thing with substance abuse evaluation. So I do recall in my ruling that I reviewed that declaration and did take into account what I believe to be his unwillingness to do those things. The next sentence, the court finds there to be objective evidence that there has been DV incidents and or physical confrontations. I'm going to strike. That was not part of my ruling. I am going to, on the next sentence that Mr. Anagnosio objected to, I'm going to change it slightly. It is going to say, the role of this court is to prevent harm to the child, comma. What did I write here? I have to read my own writing now. Not simply, add the word simply, not simply to address it after it has happened. I'm making that change because I do think the role of the court is both to address the harm after the fact, but also to prevent it. So I'm just making clear my ruling on that. And then let's go down to the rest of the strike regarding the court finds that the substantial weight of evidence leans in favor of the court preventing that. I'm keeping that sentence in. The rest of the objection regarding my findings regarding the financial support with Michelle Harrington, that is pretty close to verbatim exactly what I ruled. I did find that that led me to believe there would be reliance upon Ms. Harrington and therefore a likelihood of harm to the child should the child be with near Ms. Harrington or her son. The only thing I'm going to change is page 3, the very last part of the last sentence, where it says right now, the court believes that this, I can't read that word. Oh, this alone is a standalone basis to grant the emergency petition. I think that goes a little far from my ruling. What my ruling was is that the court believes that this is a further basis to grant the emergency petition until the date of the hearing. I will be perfectly honest with the parties. And again, we all know I'm coming into this midstream. I don't recall specifically ruling that I expected the father to feed the children dinner. I went back and looked at Commissioner Nelson's prior rulings. I'm not saying it's not there, but I don't recall making that ruling. So my preference would be to strike it, but keep in part of the visit will be between just the father and child. Because I do think that that's accurately what we discussed. Do the parties want to be heard on the dinner issue? I'm just not finding support in the record for that.
No, Your Honor, it was on the last order or the order before the last order. It was like an ex parte order. I have no issues with it going away.
Okay. And then I do also think I will strike the father has a window to collect the child 9:30 to 10. We specifically took that out, I think, at one of our prior hearings and instead added the parties are to communicate via text if there will be a delay. And we did that when we made the change to Papa Pete's. So any questions about those changes?
That's the only one that I have a concern with.
Okay.
My clients have other children as well, and it's their weekend and their only day off. Dad sometimes is more than an hour to too late. That means their entire day is gone if they've got a birthday party, and they're also waiting with a little 3-year-old child in a car for an hour.
Yeah.
And so that's the concern.
And I remember we talked about that do the parties know, has it been an issue? Because I think we made that change about a month ago. Has it been an issue where he's still showing up, up to an hour late?
I don't know that it's an issue. I mean, we haven't gotten any messages from council saying that it's been an issue.
Yeah. Ms. Winkles, I'm inclined to strike it because I do know that is something I did take out about a month ago in favor of the switch in the location. And so I do think we're going to go ahead and keep the parties there to communicate. What I'll say, if this becomes an issue, please renote it on this docket and we can revisit the issue. My hope is that it isn't going to become an issue, but I certainly can't guarantee it. But I don't want to change my ruling without the parties here to, talk about it.
Okay.
So that'll be my ruling on that order. Since it's do we have the original? Ms. Winkles, are you able to make those small changes, or do you want me to interlineate those? I'm happy to do either.
I can make those small changes, or if it's easier on your honor, if you've already got a copy there, it's up to your honor what you want to do.
I think these are pretty minor changes. So why don't I just take care of it after docket and I'll get it signed, and then
Sounds good.
And you all know that the order is signed. Okay.
Thank you. Yep. Thank you, Your Honor.
Mr. Ignacio, anything else on this matter?
No, Your Honor, that was my.
Okay. And then I know you all are still set for trial, I believe, so I don't think.
Right.
And this order extends through the hearing on that full petition. So do the parties want a review date on this docket, or what is your preference?
I think the trial's coming up so soon. I guess we can note it if we want one. Otherwise, I would just say just for the trial, because we'll have trial readiness as well.
And my concern is if trial doesn't happen, which has happened a couple of times with this case.
Right.
So.
Do you want me to set a 30-day review and then we can strike it, certainly if this has gone to trial and we don't need it?
I would prefer that, Your Honor.
Okay, let's do that. Let's set this on just as a review hearing. Mr. Anagnosta, would September 26th work for you?
Yes, Your Honor.
Okay, we'll set this just for a review September 26th at 10:30. In this case, Ms. Maddox, I will tell you I received your memorandum of law that you filed. We'll talk about that in just a minute. Ms. Powers is here. Ms. Powers, I'll come to you in just a minute. I guess my first and foremost question is for Ms. Burgess. So we'll kind of wait for her to send a written response. The reason that I set today's review was that in the initial filing for emergency minor guardianship, that there was a statement that this child has tribal heritage. There's a question of whether the child has tribal membership. And obviously, we fully acknowledge the federal Indian Child Welfare Act statute that would give precedence to the tribe in situations like this if they choose to exercise that jurisdiction. So, Ms. Burgess, before I go further looking at guardianship proceedings for this child, I was hoping to get some input from you, and I really thank you for being here, as to whether the tribe is going to exercise that jurisdiction or will allow this Washington State Court to continue with the minor guardianship proceedings. So what I'm seeing in the chat, and I'll just read it to the parties, is from Michelle Burgess on behalf of the tribe stating Washington State can continue. Do I have that correct? You can just put a yes or no. Yes. Okay. So what my plan is to do today then is to let me just make sure I have it here. Hold tight. Did they just file the full petition? Just want to make sure I'm not missing something here. So where they've just filed the full petition, then how does our court normally schedule? Get them on trial assignment? Yeah, okay. So Ms. Maddox, what is happening here is that you have, so typically 80% of the time, I should say, people start these proceedings with an emergency guardianship petition, and those are very short show cause hearings, let's say 15, 20, 30 minutes, where I grant a temporary emergency order or I reject it. And then it gets set on for trial after the full guardianship petition is filed. In your case, you've started with the full petition, which is fine. You've done nothing wrong. It just means that I'm not going to be entering an emergency order. And instead, what we need to do is get you set for a trial on whether to approve the full permanent guardianship. Okay. And because Ms. Burgess has appeared today, a couple things need to happen. So the tribe can decide under the federal act. I did get your memorandum of law, but at any time in this proceeding, the tribe can decide to change their mind and exercise jurisdiction. So I will ask that all proceedings and filings and hearing notices still do get filed on Ms. Burgess, unless she tells us otherwise and states, no, stop filing these on me. But typically that's how we would proceed. So what we need to do is get you set on for what we call trial assignment. I do want to approve your request for a guardian ad litem first. And
Your Honor,
oh, go ahead, Ms. Powers.
I wanted to add a little information for the court.
Okay.
The mother in this situation did accept service and consented to minor guardianship. That was filed with the court on June 15th. My understanding is that the father has not been served yet. I wonder if the court might want to appoint a court visitor to determine the appropriateness of serving the father. The allegations in the petition regarding the father were pretty intense.
So I think what I'm going to do, and I thank you for bringing that up. We do, before this goes on to trial, obviously father has to be served. I think because of the fact that the kid is already with this individual, I do want to go ahead and appoint a GAL who can do a little more thorough fact finding into that scenario, but also help with the service on father.
My understanding is that the statutes on minor guardianship are a little funky, and the court visitor is specifically appointed regarding issues of service, whereas the GAL is appointed in regards to the best interest of the child.
Yes, except in our jurisdiction, they are the same people. So
right.
And I've looked through the guardian ad litem order, and there is a section that states that the guardian ad litem can perform the duties of the court visitor. So
great.
So I'm going to check that box as well in this case, because yes, and again, getting used to the minor guardianship statute is an exercise in patience at its finest. So I am going to go ahead and do that. Who would we be appointing? Oh, we don't know yet. Okay. Well, I will fill out the request and then get the name from court administration. So we will do that for service. And I think if we want to take this step by step, instead of getting you set to trial assignment before proof of service on father is done, let's set a review date on this case for input from the guardian ad litem. How long out would the court typically be looking at that? 30 days. Ms. Maddox, is 30 days acceptable to you?
That's fine.
Okay. And then that would put us at September 12th at 10:30. Is that workable for you?
Yes, it is, Your Honor.
Okay, that's the first review date. Go ahead.
The last information that I received on the father was he's at one of the homeless camps at Delta Park. In
Okay. Yeah, so certainly, so the court visitor / guardian ad litem will reach out to you and you guys can talk about that. Okay. I think let's do that. Rather, I was going to give you a trial assignment date, but given Ms. Powers' statement about father and lack of service, let's start there. And then Ms. Powers, I know you did present proposed orders. We just want to move those over to the September 12th hearing.
Yeah, let's just have them in there. And these cases come up and finalize so unexpectedly sometimes. So we try and get our proposed order in.
Totally understood. And I do appreciate that. Absolutely. Anything else, Ms. Maddox, Ms. Powers, or Ms. Burgess on this case?
No, Your Honor.
Okay. And Ms. Burgess states she is available on September 12th. Great, Ms. Burgess. We'll make sure that any filings still get sent to you. And if there's additional or I guess a change in the tribe's position, certainly you can file that with the court. And I appreciate you being here today. I have this on for review today. I have received on August 10th a declaration from Norland Moxley. Since our last hearing, I have also received some additional sealed records. So let me turn it. Ms. Winkles, are you on this case?
I am, Your Honor. I represent the child.
And do we have Mr. Esau with us?
I've been out of contact with him. I've tried calling him multiple times. He hasn't called me back or nothing. Left him messages. I don't know. I haven't talked to him.
Okay. And I know I was not the judicial officer at the last hearing with you all, but it does look like an order on emergency minor guardian had been put into place and extended. And I'm trying to make sense of a subsequent order that strikes the August 31st hearing date and resets you all to today. So maybe Ms. Winkles, I'll start with you since we don't have Mr. Esau. What can you tell me about the status of this case?
Yes, Your Honor. Essentially, what we came in for last time was nobody had taken their drug tests yet. And so there were some issues with that. Everybody has now taken their drug tests. The GAL was also going on vacation the next day. The child I had not yet spoken to the child due to her schedule. Mom hadn't come on. There were just a host of a lot of things that made it get pushed out. At this point, I believe we've got a trial schedule. I believe I have a trial scheduling notice in, and I think that's the next step.
Okay. So have you had contact with Mr. Esau, Ms. Winkles?
Yeah, so the last time I had contact with him, I believe was when I was in the hospital. I believe he was also in the hospital because I think we were texting each other and kind of laughing about it. So that may be, unfortunately, why he's not here today. I will shoot him a text just to make sure. But I know that we were both in the hospital at the same time. Okay.
So we have an emergency order that we probably need to extend through the date of a hearing or trial. But right now it purports to expire on August 31st. However, that review date was stricken in favor of today's review date. So Ms. Winkles, what's your position on whether we need an extended order or whether we want to set this for review before the August 31st extension deadline?
I think that I can get, as long as I can get everybody's signature involved, so we don't have to miss work and come back here. I think we can just extend it to the hearing. I think Mr. Esau will be fine with that. Obviously, I'll note it if not. I think that's the best way, and I will have something to the court within a week, so we'll know before the deadline in any event.
Okay. Ms. Moxley appears to be trying to speak, but is frozen. Ms. Moxley, your video is frozen. You may want to turn off your video to increase your bandwidth. Okay, and then go ahead and unmute. All right, is there something, yeah, what did you want to let the court know?
Okay, so the restraining order that was actually served to Ms. Kearney's own address. And this all happened while I was in inpatient treatment. So I was never served with anything. And when I went to the courthouse to see free legal aid about how to change guardianship over to Dalen's biological family, I was presented with the restraining order at the time. And so luckily I had gone there, otherwise I would not have known about this court date. Since all of this is happening, I've been inpatient treatment. I'm in outpatient treatment. I'm also in mental health services. I live in an Oxford house.
Okay, so
there's just a lot of confusion going on with why I signed this original emergency guardianship. Kristen Kearney and I'm only catching up because I haven't been present for these court dates since I was missing.
right, okay.
Kristen Kearney was.
So let's do this. Let's back up just a little bit. So, I guess a couple things to note. It sounds like what you're asking the court, based on your declaration and your statements here today, is that you want a hearing on whether to terminate the guardianship, correct?
Yes, I do.
Okay. So I can't hear that motion today. So number one, the court received a declaration affidavit that seems to be asking for that, but that would not be, I guess, the proper way to note this on for a termination hearing. Are you hold on a second, Ms. Moxley, I'm not done.
Sorry.
Are you wanting to be represented in this proceeding by an attorney?
Yes.
Okay. And is this the first time you've appeared in this case?
No, it's not. This is my third time appearing. Like I said, I was just in treatment from June till the end of July.
Okay. Have you previously
have an ROI?
Go ahead. Have you previously discussed with the court a request to be represented?
I have not.
Okay. I don't see, we do have a guardian ad litem, Ms. Day. I don't see her on today. Ms. Winkles, do you know if she's planning to appear?
She will not be appearing today, Your Honor. She is actually on vacation and let the court and all the counselor let us all know last time.
Okay. So, Ms. Moxley, what is your current income?
I am currently not working right now. I was working at Little Caesars, but I had to quit my job due to people using drugs in the workplace. So I'm currently looking for work. I start full-time school to SNHU on the 28th for a bachelor's degree in psychology.
Okay. So what I'm going to do for purposes of our next review hearing, and as this case moves forward, is I will find you indigent and I will appoint an attorney for you. After doc, I can't give you the name right now because I don't know who that person will be, but we will get notice to you. Do you have an email address that you use? At gmail.com.
Yes.
Okay. I'll work on that order after docket today. And then what I'm going to do is since the order right now sets to expire August 31st, Ms. Winkles, could we put you on for review August 29th at 10:30? And if for some, obviously, if we get the order extending by then, we can strike that.
Yeah, I'm having the worst internet.
I know.
I apologize. I've got nothing. I do have 2 trials that week.
Okay.
But hopefully I can at least pop on or get somebody else to do it for me. So that'll be fine.
Okay, let's do that. And Ms. Kearney, are you available?
Yes, Your Honor. And then Daylin wanted to say something to the court whenever she has the chance to do so.
Ms. Winkles, I'll let you.
I'm fine with that. She's a very, very mature child.
Okay. All right. Go ahead, Ms.
I don't want to live with my mom. I don't want to have contact with her. I don't want to live with her at all. One time, I know this is probably like, I don't know.
Okay.
But one time,
I hear what you're saying, and I did see that in the documents. Just because your mom has asked for counsel, I'm going to kind of wait so that her counsel can hear your statements and respond to them. But I hear what you're saying, and I am not terminating the guardianship order today at all. Okay. You would have, if the court was, had a proper motion in front of it to terminate, I would absolutely give you the opportunity to testify via your counsel's wishes. Okay. Okay.
Galen, you can give me a call at the office. Okay.
I didn't mean to cut you off. I just wanted you to know that I'm not terminating the guardianship today. So we don't need your testimony. And obviously I know it's emotional to talk about your relationship with a parent, and I don't want to put you through that if we don't have to. Okay. Okay. So we'll have a review on August. So Ms. Moxley, this is for you too. We're going to have a review date on August 29th at 10:30. If the parties can get an agreed order to me before then, we can strike that. Otherwise, we will talk about whether to extend our order at the August 29th hearing.
All right.
Okay.
Okay. Your Honor, can I say something or ask something?
Go ahead. Yeah, I might not be able to answer it if it's legal advice, but go ahead.
Okay, so the only reason the order that I have to terminate the guardianship wasn't filed yet is because I have, the attorney told me to wait until after this review hearing to go ahead and file that. My sister Brianna is actually here via Zoom. So I guess I can go ahead and file that today with the court if necessary.
Yeah, if you want to file a motion to terminate and note it on for hearing, certainly that is your prerogative. I will not tell you no. I'm just telling you today it's not properly in front of me.
Okay.
Okay. And I should have Gianna Harrington. Is that correct? Ms. Harrington, are you online with us? Can you hear the court?
Yes, we're all here.
And just tell me what you mean by you all. I can't see any of you.
Me, Gianna Harrington, Haley Murphy is here, Chloe Murphy is here, and Shannon's mother, Jan Kamrath, is here.
Okay. So typically, I know that I have less concerns with the 16-year-old, but typically with the younger child, we would not have them present at this stage unless we're talking about taking testimony. Are you able to turn your camera on?
Yes, here, hold on, I can. One sec, it's the school computer, right?
So let's talk first about, this is a new filing. I did see that our court on an ex parte basis approved the immediate order and hearing notice that you filed. That was done on August 8th. And then it was set on for our hearing today.
Yes.
What I want to first look at, I see Mr. Murphy, you are there.
Yes, ma'am.
As respondent father, and Ms. Murphy, I see you there as respondent mother. Is that correct?
Yes.
Okay. Have both of you received service of the emergency minor guardianship petition?
Not technically, but
I don't know how to answer that question, really.
Nobody served me any paperwork.
Okay.
I had found it on the counter at my house when I got home 2 days ago.
Okay. So Ms. Harrington, at this point, I would like to ask the kiddos to be in a different room, especially the younger one. I don't think, as we work through these procedural steps, I don't think it's beneficial to them to be present.
Yeah, she's going. The older one was the co-petitioner, though.
I understand. And that's why I said my biggest concern was the 10-year-old. I did see the statements from the 16-year-old, and I'll probably talk to her about whether she wants her own attorney.
Okay.
Okay. So that was one question I had was I'm not finding that the two parents have been served. What can you tell me about that?
They were both served by Jeremy's ex-stepmother. Well, I guess they were not technically married, but Jeremy's, hold on, I wrote it down when it happened. She went to the police station to document it.
But that didn't give me the paperwork. I didn't receive it until 2 days ago when I got home. It was sitting on my counter.
Okay, so Mr. Murphy, let me just ask you, have you now received the paperwork, which should be the petition and the immediate order?
All I've got is immediate order.
Okay.
That is all I have received.
You don't have the original petition that was filed?
This is a photocopy. What I have is a photocopy. And no, I do not have the original. I have an immediate order. That's it.
Okay. So Ms. Shannon Murphy, have you received any of these documents?
I've received the same thing that he has.
Just the immediate order?
This is what they received.
Yeah, that's the immediate order. Have they been served with your petition?
This was all that the court gave me to give them.
Well, okay. That's a little different than what I'm asking you. You are the one who you and the older child initiated the request for an emergency guardianship. That is the paperwork that needs to be filed on them, so they know how to respond to the allegations that serve as the basis for your request. So that's what I'm trying to ask. On the last page of your sheet, I'm not seeing where you, in your motion, where you served them with the statements that you have filed with the court about why you're requesting this.
We went there to ask, what it is that we actually serve. And he gave us these 3 pieces of paper and said that we couldn't do it ourselves, that it had to be done within 48 hours. He only gave us 1 copy. So I thought that I would make copies of it and have that delivered to them. I thought that's what I was supposed to do.
Okay, well, it's a little different than that. And if you read the instructions on the motion that you filed with the court, it does state that you have to serve all other parties or their lawyers a copy of your papers.
Okay.
Okay, so that's on the very first page. Not faulting you for that. I completely understand that working through these proceedings can be difficult. But
That's a lot.
It is, but we do need to get them served before we can make a decision on whether this is in the best interest of the children. So let me first ask before we set dates and talk about.
We are in process of submitting an objection.
Okay, so Mr. Murphy, are you and Ms. Murphy both objecting to the guardianship?
Absolutely.
Okay.
Yep.
Okay. And are you seeking representation on this?
I am. I'm just trying to come up with the money at the moment. I do have an attorney lined up, but I have to have the money for it.
So you are seeking your own counsel?
Well, if I can, I'm trying to come up with the money. That's the problem. I've got to come up with the money.
Okay.
And I'm trying.
Okay. Do you think that you would qualify for court-appointed representation? I don't know if you're working full-time.
I'm working full-time, but I've been out for the last 7 weeks on an injury.
Okay. Are you receiving any income for the last 7 weeks?
I've received one small check from L&I.
Okay. When you were working full-time, just approximately how much were you making?
$30 an hour. I was making about $1,000 a week or something,
Okay.
roughly.
When do you expect you'll be released back to work?
Hopefully by the beginning of September.
Okay.
They were wanting surgery and we're trying to go around that.
Okay. And how many dependents do you take care of on that salary?
Well, right at the time, would be myself. I
Okay.
live with I have, and obviously the girls are not here.
Okay. So you probably would be well above our guidelines for court-appointed counsel. When we set the review date, let's re-review that issue. If you still aren't working, I can reassess whether you would qualify for court-appointed counsel. Okay.
Sounds good.
In the meantime, I'll just make a note that you're seeking your own counsel. Ms. Murphy, what's your status as far as income and whether you're seeking counsel in this proceeding?
I work full time, but I make less than $18 an hour, and I was taking care of the girls. So I would absolutely pursue some kind of help.
So what would you say, what do you bring in per month on your salary?
I don't know off the top of my head really right this second. I don't know.
Let me ask you this, which might make it easier. Do you receive any sort of state assistance, including
I
like
do.
state medical or food stamps or anything?
Yeah, I receive food stamps. Yes.
Okay. Then you do qualify for court-appointed counsel. So
okay.
I will appoint an attorney to you at county expense. I'll fill out that order. Again, just like I said to the prior case, I don't have the name of that individual. I'll have to get it from court administration, but we will get an order filled out.
Okay.
The next question I want to ask, and Haley, is she the 16-year-old?
Yes.
Okay. Is she present there with you, Ms. Harrington?
She can be.
Yeah. Could you call her back into the room?
Yes, I am.
Hey, Haley, I'm Commissioner Jill Karmy. I'll be hearing some or all of this case. Do you want to be appointed your own attorney through this matter?
Yes.
Okay. And are you, I'm assuming that you're currently in school, or you will be as soon as school starts?
Yeah.
Okay. So we'll get an attorney appointed for Ms. Murphy. And then I think what we'll do in this case, and Ms. Farr, I have you here, so I might pick your brain if you don't mind. We do have some questions about service. At this stage, would you recommend the court appoint a court visitor for that? Both parents are here, so they've had some notice.
So since both parents are here, both of them can agree to accept service by email, and that should resolve the problem without appointing someone.
Yeah, that's what I was kind of wondering. So I appreciate your input on that. Thank you.
You're welcome.
So Mr. Murphy and Ms. Murphy kind of circumvent having to add even more players to the case right now. And that's not to say at some point we don't appoint a guardian ad litem. But at this point, just for service, do the two of you have an email that you would agree to accept service of the petition on so you can see what allegations are being made?
Yes, of course.
Okay. So Mr. Murphy, why don't you give me that email? Gmail, yes. Okay. And then Ms. Murphy, what is your email?
So I don't know if I'm okay with that. If she can just email me anything that says.
Now that I understand fully.
Mr. Murphy.
No, it needs to be handed to me. That's not okay. I'm not doing it over email. That's not okay. I was misserved. Nobody gave me this last set of paperwork. Nobody handed me nothing. It sat on my counter when I called.
Mr. Murphy, stop.
Okay.
Ms.
I'm
Murphy, stop.
Jeremy, stop.
I'm gonna mute you in a second. Stop. Ms. Murphy, I'm talking to you before Mr. Murphy interrupted and went on his tirade. Ms. Murphy, why are you not okay with getting an email that circumvents a lot of the issues in this case?
I'm not familiar with it.
You're both making this more difficult than it needs to be.
I'm not familiar with the situation. Does that mean she can just make up other things and email it to me, and then that means that I've been
No, what I'm asking, you're both here. Okay. Both of you, Mr. Murphy, Ms. Murphy, you're both here, which means you have notice of this hearing. Frankly, I could tell you to come to court and get a copy of the motion, but instead I'm asking Ms. Harrington to serve it on you. Okay. Most of the time when there is lack of service, the parents don't know about it. And so we have to appoint someone to go find them. Thankfully, you are both here. You did the responsible thing and showed up. What I am asking is if you will allow the papers to be emailed to you so that you can see what the allegations are against you. The alternative is she can have a sheriff serve them on you if that's what you want, but this is a much easier route. Oh, Mr. Murphy, you're shaking your head. You want the sheriff to come serve you?
The sheriff come give me the paperwork. Well, I mean, because I wasn't even served with the paperwork.
All right.
I wasn't even served with it. And she didn't even give us all the documents.
All right, Mr. Murphy, what's your service address? Where can the sheriff find you?
Depends on the day.
I'm not going to play this game, sir. Where can the sheriff find you? Otherwise, I'm going to sign an order allowing electronic service.
I was looking at on the email thing. I did not understand that, obviously.
Do you want the paper served on you by email or by the sheriff?
Given the paperwork to begin with.
Excuse me? You're cutting out. I don't know what you're saying.
I was not even given the original paperwork or nothing to begin with.
Mr. Murphy.
Send it email, just whatever.
Perfect.
Yeah.
So you have his email. Ms. Murphy, would you like to be served by the sheriff's office or would you want to agree to electronic service?
Well, can I have my question answered?
What is your question?
I'm not familiar with the situation. So does that mean she can just make up more things and have it served like through email and then that makes it official, or
no? What my decision today, if you want to agree to it, you don't have to, is that her original motion, which includes why she's requesting this petition, would be sent to you via email so that you can respond. That is it.
Okay. But I'm saying like for future, if she comes up with more things, if she makes up more things and emails it to me, does that make it, is it just for this case right now? The petition for right now?
Right now, my decision would be whether or not she can serve you by email of her original petition.
That's not what I'm asking.
We're talking about. I'm not addressing anything further in the case right now.
But me agreeing to the email is only pertaining to this
yes,
paper that she was supposed to serve.
Yes.
Hold on 1 second.
Alternatively, you can give me a residential address where you can be served in person, whatever you want.
How about residential address is fine. I'm having some issues with my email.
Okay. Do you have the chat feature so you can put it into the Zoom chat?
I'm pretty sure I do.
Okay, let's go ahead and see if that works.
Okay.
Did you find the chat feature?
Oh, I'm sorry. No,
You did not. Okay.
I'm sorry. I haven't done a lot of Zoom. I'm not super familiar with it.
Okay. Let me just go to what I have. Oh, it just states unknown. Okay. What I'm going to do, let's set your review date, and then I'm going to stop streaming on YouTube just to get your address. So what I'm going to do is I will extend the emergency immediate order through the date of our next hearing. Let's set that two weeks out. Let me ask the court's input, see where we're at that point. Okay. So we're going to set you back on this docket August 29th at 10:30. Okay. And at that time, we will, if all our ducks in a row and attorneys are on board, we may discuss objections to the order. We may set a future show cause date on the emergency minor guardianship hearing. It just depends where we're at with these issues of service. So August 29th at 10:30, Ms. Harrington, you will need to serve Ms. Murphy in person. We'll get you her address. Don't log off yet. We're going to get that address. Mr. Murphy, you have his email just to serve him the original petition. Any questions for me? Otherwise, I'm going to go off of YouTube just to get Ms. Murphy's address, and then we'll adjourn docket.
I have a question.
Okay, let Ms. Harrington go first.
I just wanted to confirm that I had Jeremy's email right. Was it J?
Yes.
Okay, thank you.
Ms. Murphy, go ahead.
I just wanted to, so I can't contact my youngest daughter and message her anymore. Like, is that what I understand?
So basically,
Let me pull up the emergency order. Hold tight.
And is this an appropriate time to ask?
Hold on. So right now, at this point, there is a one of our judicial officers, an elected Superior Court judge in this county, did sign an order on August 8th that does include a temporary restraining order against contact with the children.
That's bogus.
Okay.
That's not okay.
And there's nothing I can do about it. I just don't understand.
Yeah, I know. There's got to be something we can do about that.
Yeah, you can file an objection.
So in other words, my kids taken away from us until then? Is that what you're trying to say? They were just taken away from us until whoever decides it's okay to give us a chance to even talk about it or anything?
Okay. What I'm going to do.
What happened?
I'm telling you what has been signed by this court. I'm asking you to file. I asked you if that's what happened. Mr. Murphy.
God.
I'm sorry. I'm very upset about all this.
You're asking a question and you're not letting me respond. So do you want an answer?
Get straight to the answer. Just like Shannon's question. You did not want to answer that right out. You were beating around the bush and you went the long way. You know, I mean, why can't we just get the straight out answer?
Mr. Murphy, you are testing my patience.
I'm sorry, but I'm very upset about this.
I have the ability to mute you. I have the ability to mute you.
I understand that.
All right. Nope, you've been muted. So, Mr. Murphy, I'm answering your question. You can choose to listen to it or not. I already answered it. On August 8th, 2023, a judicial officer in this court did sign an ex parte immediate order granting immediate emergency minor guardianship of the two children to Ms. Harrington. As part of that order, and based on their request, it does include a temporary restraining order. This does preclude you from contact with the children. What I will ask Ms. Haley, since you are there and you are 16 years old, is it still your wishes to have a temporary restraining order in place with Jeremy Murphy and Shannon Murphy?
Yes.
Okay, I'm going to go ahead and keep that in place at least through our next date of August 29th at 10:30. Okay, I'm going to go off of YouTube. Ms. Murphy, stay with us to give us your.
She left.
Yep. All right. So we're just going to show, I'm going to make a record here that Ms. Murphy and Mr. Murphy chose to log off after being given notice of the next hearing date. She was supposed to give us her residential address for service. At this point, I have no other option but to appoint a court visitor. That court visitor, Ms. Harrington, can help you work through service issues on this case.
Thank you.
And again, will I get that name from court administration? Okay. So I'll work on these orders after docket and we'll see you back on August 29th. Thank you for your time. Haley, thank you for being here.
I wanted to ask one more question.
Okay.
August 29th is the day that the girls would be set to start school if they go in this county. Should I go forward with enrolling them or?
I believe the emergency order does give you school and educational decisions. The order that I redo through August 29th will do that as well. So for the time being, I'll let you make the ultimate decision on where, driving wise, where you want them to be and that sort of thing. But right now you do have the school and educational decision-making authority.
Okay, thank you so much.
Yeah. Okay. And then I'm going to call our last matter dismissal. I don't see any parties here. I know Ms. Farr was originally court visitor and we did vacate that. And Ms. Farr, I appreciate your help on that matter previously. I was hoping to get input from the parties about whether the dependency action was still moving forward. But I think at this point, with no appearance from the parties, and as best as I can tell, do we still have that pending dependency going?
I don't know for sure.
I can try and look up too.
When I talked with the AAG, he was pretty clear that they were going to do placement and work towards adoption, I think, through the dependency.
Okay, and that was Mr. Rothman, correct?
Correct.
Right, yeah, that was my understanding of his position.
I'm showing that there's a shelter care hearing shelter care review hearing on the 28th at 9 o'clock.
Okay, so they are moving forward. There's a shelter care hearing set up. So I am going to go ahead and enter a dismissal of the petition on the minor guardianship docket.